domestic abuse in all forms. I'm your host today, Jackie Ressler. I represent a group of over 65 top podcast hosts and divorce professionals who have united to carry the message to increase awareness of and create change in the world of domestic abuse. Our mission is to bring understanding and change to legal professionals, divorce professionals, family and criminal courts, and legislatures. Today, we have a fantastic guest, Abbie Godles. She will walk us through whether families with a history of domestic violence should pursue mediation, and if so, how to succeed in it. So welcome, Abbie.
Good morning. Thank you for having me.
I'm so excited to have you here. This is actually a topic that I think comes up in many of the cases that I have. So I'm a divorce financial advisor. I've been working on divorce cases for about 26 years. It's my whole practice. And I do a lot of mediating and collaborative law, and questions about domestic violence cases come up pretty frequently and whether or not they're appropriate for mediation. Can you give us a little bit of your background and how you got into being a family law mediator first, and then we can dive into the topic?
Definitely. So for starters, my background is that I am an attorney. After law school, when I was already leaning towards family law, I did decide to pursue my master's in forensic psychology with an emphasis in family violence. To me, I have always been interested by the intersection of psych and the law, and especially knowing I was going to be working in the family law world, I wanted to make sure that I was prepared to help any couple walking in the door, whether there were psychiatric illnesses at play, substance abuse issues, and of course, as you mentioned, DV is a pervasive issue. It can touch anybody's lives, no matter your demographics. And I wanted to know that I was going to help my clients succeed, no matter the issues they were facing.
So do most of your cases, do the couples come in with an attorney, or do they come in on their own?
Yeah, so my practice does tend to focus on pro per clients, which are those who are representing themselves. For me, when I did start exploring mediation as a really beneficial way that couples and families could maximize their agreements, really customize their agreements, to me, it's more powerful if you are the ones controlling the whole show, helping drive the car the entire journey. That said, as we delve into today's topic, DV, given the nature of things, frequently does require additional players and protections. And in those cases, I am focused on working with other professionals who are passionate and trained. And so in those times, I will be working with represented parties.
So do you have a screening that you do when people come in so that you can determine if this is a domestic violence case or if there's an equal power balance between the parties?
Definitely. And actually, I can kind of start diving right into kind of the overarching question you led with, which is, is this appropriate? And professionals and the couples themselves do wonder this, because when you're going to mediate, it is meant to be this voluntary process where you are able to participate on your own free will, negotiate, reach these agreements. But that said, you do need to consider it and find professionals who are screening. Not all professionals screen, and that should be your first red flag. For me, I am a huge fan of Indiana University School of Law's created assessment, because they are constantly in their clinic testing and retesting this measure. So anytime the tool may need to be updated, they've got that real-time feedback that they're working with. That said, there is no one right screening tool. The important part is that your professional is screening. No DV is created equal, and screening is going to first and foremost alert your mediator whether the specifics of your DV history is actually appropriate for mediation. from there, the information that is garnered can be used to adapt the process and make sure that it is tailored and safe. It's always going to be your specific history that dictates things, and there will certainly be times where, unfortunately, it is an extreme history of violence that would require litigation to ensure the safety of the parties.
Right. And how do you make that determination? So for our listeners, when people come to you and if they are concerned, they want to mediate their case, they want it to go smoothly, they want to have as good of a relationship as they can when the divorce is done. Can you walk through, what does it look like when you're doing a screening? Do you do a screening individually with each party alone? What kinds of questions should they expect to hear?
Great questions. So I don't know personally of anyone who screens parties together. Most schools are going to dictate it should be one-on-one. I can't envision a scenario where it would make sense to have the couple together for the screening. You do want to ensure that when you get each person on their own, you're creating that safe space where they are not concerned about the information they're sharing. The information that the professional should be working to get, and again, it will vary based on the specific screening tool they're using, but they should be looking at the full picture. They should be asking you questions about points in time. So again, DV can be looked at the entire history of your full relationship, but we know that when someone is getting ready to leave a DV relationship, that is unfortunately when things can become the most dangerous. So it is many measures, and the better measures should also be looking at a more recent period of time as well. The types of things that it's looking at are going to be things from, has your partner done X, Y, or Z? And some of those things will be focused on verbal abuse. Other things will be focused on substance use issues. Certain measures will already be exploring whether there is child abuse or other abuse going on. Domestic violence is the biggest picture of familial violence. And so, again, as your professional is interviewing you, essentially, they should also be considering what questions outside of their screening tool they need to be asking. The key here is getting as much information and the fullest picture so they actually know what they're working with to help you best. I'm going to pause there, and I've said a lot, so see where you want to take things.
Sure. So that's great information. Let's say that I have a lot of cases where I don't think that my client is aware that they are a victim of domestic abuse. I'm a financial advisor, so most of the cases that I see, I'm only dealing with the financial piece. And many of my clients are victims of financial abuse in terms of, I can give you some examples where they had no access to money. They had to justify everything that they've spent. Their spouse has them sign the tax return with their hand over the income number. They're not privy to any financial information, but a lot of my clients feel like that's just normal. And so when you are, I'm sure that a good screener like you're asking all kinds of questions when there's situations of maybe more subtle abuse.
Yeah, so first and foremost, it's actually a great point you brought up, and it's not even specific to financial abuse. There are so many couples out there who have experienced some form of abuse, and yeah, just like your clients, write it off as, oh, isn't that just, that's what everyone's marriage is like. And it's really unfortunate, and some of that is just the culture that is out there. Part of it is just, us helping educate and shouting louder from the rooftops. But that is one thing I love about the screening measure I use, because it is set up as a more conversational version where it does allow you to explore. I'm going to ask you these questions, and Not all of them may always make sense as to what I'm trying to get at, but I promise they all have a purpose. And it does. All the questions in it clue me into, again, that idea of thinking through additional questions that may need to be asked. It is already a comprehensive measure that just does get it so much. And the way that the instructions are set up, it is, again, less, I feel like other ones seem to put people more on the spot. But this one is just exploring. Let's see what your answers are. And it really gets at the layers, because even if ultimately no abuse is found, this measure just even gives me good insight into how you guys communicate. It is going to give me so much information, no matter your specifics, to set the mediation up for success. And in the DV cases, it is absolutely imperative that you are finding these professionals who know how to get the info and make the modifications needed, because that's the only way that it's actually going to be supportive and healing. Otherwise, it can become a lot more detrimental and honestly just as destructive as litigation.
What are some of the accommodations that you can make when you determine that there is domestic violence in a case?
Yeah, so it's going to look like two sides of the coin. One side is how you can structure modifications to the process, and one side is looking at modifications to the agreements. So I'll kind of start us off on the process, and then we kind of pause before turning to the agreements. But if you are going to be meeting in person, which sometimes is still an option, and again, based on the information your mediator gathers, they will be able to better determine, can we meet in person with modifications, or are the modifications shifting from in-person to some other form? So with a physical space, sometimes just having a large room and a large conference table, and just that physical space can be enough. Obviously, that can quickly be trumped by the level of violence that has occurred. And so other ways are to ensure that where you're meeting, if there's concerns over weapons, make sure that there's metal detectors that work, have your parties meet in separate places. If there's even separate entrances they can come in. And it may even look like one of the options in kind of bigger picture shifting is, instead of just lengthening the size of the room and conference table, is to use the method called shuttle mediation, where the parties are in completely separate rooms and they are not having to see or directly interact. And as the mediator, I am shuttling from one to the other. And again, depending if other players are involved, again, the parties stay where they're at. It's the professionals that are going to be moving around. You can also ensure that a safety plan is put in place so that if and when things become worrisome, immediate action can be taken. There is already a plan in place for that specific facility. It may dictate things like which entrance each person will use, or having them arrive at different times. It may be laying out provisions to what would trigger the ability to have an escort walk each party to and from the car. Depending on the level of violence, one of the more extreme versions is called therapeutic or impasse-directed mediation. This is going to be kind of the fullest picture where, again, it's the most extreme violence. There's concerns of lethality, that there really could be, unfortunately, concern of homicide. And so this type of mediation is really focused on not healing the relationship to a point that the parties are friends, because given the history of violence in these scenarios, that's certainly not likely. But given the fact that in times where there's kids, you do want to get the parties to a place where they can communicate. So this is a style of mediation where, yes, you're focused on the base of mediation, but in order to qualify, you also are getting the parties to agree to go to psych classes or counseling as appropriate. And that psych support is focused on getting them to turn their attention back to the children instead of the adult issues. And so it's a very it's therapeutic mediation. It's therapeutic based to really set the parties up to be able to do the mediating. And kind of in between those two extremes are middle options such as, Zoom. I know we're not technically on Zoom this morning, but video conferencing is everywhere post-pandemic. There were certainly people who utilized it before, but I hesitate to say there's not a single person, because I'm sure technically somewhere there's a person. But everyone knows how to hop on Zoom. You get to stay in your own place, and that can, again, removing the physical space can be a way to ensure the safety. And the last thing I'll note is just you can do a shuttle method through Zoom as well. Keep the parties in separate breakout rooms and still be shifting between them.
So I have so many questions to ask you. I hope that I have enough time to get them all in. But, as you were talking, before we get to the accommodations that you put in the actual mediation or the settlement agreement. As far as that process goes, so what is someone, and I guess it probably varies by state, right? So what state are you? You're in Arizona.
Yeah.
You're in Arizona. So I would assume that the different types of mediation are going to vary by what's the norm in the state and what kind of training is available to mediators in the state. Is that accurate, or?
Yeah, so some states will require mediators to be attorneys. Other states won't. Arizona is a state where you do not have to be a licensed attorney to be a mediator. There are certainly pros and cons to it. And the fact that you have DB in your history, I would tend to say that you want to be looking for a professional with either a legal or psych background, because again, you are more focused on just someone who is well trained and has the knowledge and experience. But again, just because DB is there and there is a lot of kind of extra interplay with the legal world, that doesn't mean that if your state allows non-attorney mediators, I would encourage you to equally explore and just look at the individual's full background.
Right. And maybe ask them what their process is, because again, yours is so detailed and you provide so many precautions that I'm sure a lot of mediators say, yes, I do that. But, to get into the nitty gritty, when people are looking for a mediator that is specifically has a practice that accommodates domestic violence, I think that it has got to be fairly unique. What do you do? Are you welcoming to someone that needs to come into this space with their mental health professional or with a trusted friend or relative, or do they have to come by themselves?
Yeah, so a few of the methods, there's even kind of one step down from the therapeutic mediation, but again, a slightly more robust version called Med Collab. And as a collaborative professional yourself, you'll already kind of probably better understand some of the nuance just given you've gone through the whole training yourself. But this is an approach that does kind of, it takes all of the benefits of both mediation, but some of the more protective aspects of collaborative law, and it bunches them together. And so this is a really great method to use to build out a team. So as far as your question about friends and family, that is, at least in my practice, I only invite them into the space if they are beneficial to the specific conversation and that specific issue. It's not there to be an advocate and support. That said, I do believe in DB cases, again, I always hesitate to say, all or never, because I'm sure there's always that one exception, But by and large, when DV is an issue, there are a lot of other factors at play. The psych side, the finance side, there are a few key areas more than others that really get pinged alongside. And so in this case, as you're aware on the collaborative law, but for everyone listening who isn't as familiar with collaborative law, this is a way to approach divorce and custody following what's called the Lego model. And it's what it sounds like. You build with Legos, you build your team. So in this process, obviously as a baseline, you've got the mediator. In DV cases, I do recommend that it's a non-starter that attorneys get involved. But again, if the specifics of your DV, there is the potential it doesn't warrant those attorney advocates. But I do believe more often than not, getting the attorneys involved as a base player alongside that mediator is key. From there, though, you do consider who else do we need to either bring into the room or who do we need to work with for you to supplement outside of our mediation session. So it could be linking up with someone like yourself for one or both clients to get the financial support they need. It may be bringing the psych professional into the room to help ease each session and, again, teach skills and shift the focus in real time. It can look a lot of different things based on, again, no DV is created equal. It always comes down to what are the specifics of your case and your DV history.
I find that in a collaborative case, it's so important to have a mental health professional on that team. And even when clients say to me, we don't need the mental health professional, it always comes to a point in every case that I've been involved in where we really need to bring the mental health professional in to help, again, even give the parties a ability to have a break for one-on-one coaching if they need to, or just to take a break to ease some of the tension in the room. But in a domestic violence case, that's got to be even more important. Do you ever worry about your own safety?
Yes. I mean, again, it's obviously more so when we are in person, which I'm doing minimal of these days. But yeah, I don't even know how many times I've said unfortunate in this episode, but it is just a very daunting topic where so many of these things are unfortunate. But there will be times where the abuser, because so much is about their control and power over their victim, that just by virtue of you wanting to step in and be genuinely helpful to the situation, they are going to shift their focus to now you're the bad guy. Your staff's the bad guy. The security guard at the random office space you rented is the bad guy. And so some of the things I spoke about earlier, like coming up with a safety plan as that just in case ready to go. You can build out things if there are concerns beyond just the parties themselves. And again, thankfully, as I've shifted so much around the pandemic, more virtually, it's definitely become less of an issue. But abusers are unpredictable in the best of times, and now you're at the point where you are trying to change their day to day and give their victim their voice back. And again, you're trying to be that neutral person focused on the situation and doing right by more often than not the kids, but certainly the victim, even if there's no kids involved. And it's just, it sucks, but it happens that they will just laser focus that you've stolen their power.
I'm sure. I mean, it's thank goodness that there are professionals like you that are willing to do that to help people get through this situation. But it's got to think about that's a little bit scary for you sometimes to go into that situation where how could it not transfer to you as the person trying to give one side their voice back? So
yeah, and in cases, although you're still acting as a third party neutral to the whole negotiation, you are doing a bit more work in helping rebalance the power.
Right.
That can further the issue because it can appear as bias. Now that said, a few years back, and I didn't look this up before because I didn't know it was going to come up, but the ABA, the American Bar Association, did release an ethics report, like an opinion, where they give advice on best practices. And they did actually note in that report that even if it appears as bias, because you are still doing the appropriate just balancing, you're not actually becoming an advocate, you should not worry about the appearance of bias in those times.
Really?
When normal mediators are always worried that they don't want to appear biased. But I thought that was pretty interesting.
There's that. That's a balance between being neutral, being an advocate, and then also making sure that everybody walks away with a really equitable solution to whatever their issues are that they're working through. Let's talk a little bit more about what do you put into an agreement? You said that you can make different accommodations for an agreement when there's been a domestic violence case. And I think that's wonderful because I know that clients go back to their agreement constantly. Some people think that they're going to put it in a drawer and it's just done. And most couples are going to look back to it. So the wording is so important. How do you provide accommodations in DV cases?
So as an overarching, this should be a non-starter. You need to be drafting very specific plans. You don't want to leave any opening that the abusive partner can say, I didn't understand, I thought it meant this other thing. Don't give them a chance to exploit some poor wording or just not detailed enough wording. You want to focus the language on both protecting the kids, also just already getting ahead that if things go south again, you can already be building in things that can help if you do need to call police or if you do end up back in court. As some general kind of categories, and then I will turn to some specific examples that come up across, many couples would want to consider these specifics, but to give you some general ideas where you could just get creative on your own, find ways to limit the abuser's access to the victim survivor parent. Consider ways to limit or have supervised visits with the kids. There is, different states call it different things, but there's going to be in all states 2 sides of custody, legal custody or legal decision making, depending on what your state calls it. The physical custody is going to be either visitation or parenting time. Again, the terms vary, but you see the 2 sides of it. So you could also consider that the abuser can have the details add up that they could have visits and parenting time, but they don't get to help make the decisions.
Okay.
Whether child support, reimbursements, or any other monetary stuff, set out ways that there's going to be automatic payments. If there's other provisions that can be similarly self-executing, get ahead of as much as possible. Similarly, for the abuser's compliance, already set out backup and contingency plans for if this doesn't happen, this is the new plan. Or if this does happen, we step it back up. It can be up and down. Consider all ways that this could go for better or worse and already build it in.
And that's unique. That's very unusual to have that kind of detail. In my experience, anyway, it's very unusual to see that kind of detail in cases, which again is a reason why somebody would want to go to someone like you that specializes in this and not just a general mediator that does, everyday divorces.
Yeah, no, it's definitely, again, even like one of the specifics that, again, if you're not doing this day in and day out, or at least that it is a key part of your repertoire, things like here in Arizona, I'm in Phoenix, so obviously I am in the largest county. So anyone else in Maricopa County, FYI, if you didn't know, but exploring your state, this is a nuanced example where certain states will have a DV program or a DV court. So Maricopa County does have that. And that can be where there are criminal legal issues bumping up against the divorce or custody matter by virtue of the violence that occurred. These are things you can build into the parenting plan that is going to be an intervention on both the criminal and family side. But again, like you noted, if you're going to a professional who's just doing more general matters, this is not something that would come up with the average couple.
Sure. Are you allowed to be called in as an expert on a case? If there's a criminal case, are you allowed to be brought in to testify based on information you got during the mediation?
That's going to depend on state-specific statutes, but my guess is in all states, no, because mediation is a confidential process. Here in Arizona, mediators are very limited. You don't have access to the mediator's notes. They can't be called to testify. Everything related to mediation is property of the mediator to be destroyed and not to be voiced in court. I mean, there are limited exceptions, but by and large, the mediation is your chance to have this confidential, non-litigation process. And if this would not be a time where it would be exploited. But the idea is that they don't want a chance that what was said in the mediation room is exploited in litigation later.
Sure. And that's a good way to ensure someone who's nervous about going into mediation, whether they are the victim or the perpetrator, that there isn't going to be that layer of that it's a safe space for them to talk about the truth as far as they can report the truth or they recognize the truth without worrying about you having to come in and testifying about that. What if there are children involved, though?
Yeah, so one other note, just before I answer your question, another way to kind of extend that is beyond the confidential generally, even if you're not doing the shuttle method, you can be in the main joint session and still at certain times caucus or have a private side meeting with just one party. So if they were, worried about things coming in the main space, we can have a side moment and I can help bring that back to the main space. As far as the kids, again, that's going to be a few things. Depending on their age and the specifics, kind of like the friends and family question earlier on, it may make sense to involve the kids. Frequently, again, every case is different, so I do hesitate to say frequently. It doesn't make sense. It's always going to be what is appropriate. It may be that in the agreements or just throughout the process in a more informal agreement that there are, the child or children, they are getting psych support. You can build in provisions to the parenting plan that works to strengthen their support, whether that is familial support or professional support. On the flip side, for their abusive parent, it can also be dictated that the abusive parent or the abusive parent with the child, that in whatever combo of family members, that the psych and therapy side of things is already built into those agreements, that you are working to continue the healing process even once those agreements are in place.
Okay. Thank you so much for this information. This was so valuable. Abbie Godles, how can people find you if they have questions or they want to get more information?
Yes. One more thank you, because I could have said so much more. This is a really deep topic, so definitely get in touch if you have questions. My info does seem to be popping up on the screen, but I can be reached by phone or email. You can find all my contact info on my website. It will be the easiest way, modernlegalsolutions.com. And then that way I don't have to sit here and speak out all the detailed info. But again, either on the screen or modernlegalsolutions.com. And feel free to reach out with questions. I am in Arizona, but I'm certainly happy to answer the general questions that I can outside the state, because plenty of topics are not state specific, of course.
Of course. Thank you so much. And everyone who's listening or watching, we hope that you got a lot of information out of this episode, and we look forward to you joining us next time on Divorce Coalition Live. Bye.